Hello, welcome to Everyday Wakili.
My name is Phoebe.
My name is Doreen.
And mine is Agnes. This is a weekly legal podcast. We analyze new developments and changes in law, as well as landmark court rulings, by relating them to real-life situations and giving legal answers with an added value of fun. This is our first episode, and we shall be discussing the Data Protection Act, which we shall discuss in 2 episodes. Today, we shall cover the establishment of the Office of the Data Protection Commissioner, the registration of data controllers and data processors, principles and obligations of personal data protection, and grounds for processing of sensitive information. Phoebe will take us through establishment of the Office of the Data Protection Commissioner.
Thank you, Agnes. So before I delve into what the Act has said about establishment and of the Office of the Data Protection Commissioner, I'll just give a brief overview of before the enactment of the Act. Data is a very powerful tool in our society, and it comes with risk despite its advantages to us. So the use of the digital technologies in data processing has increased, both in volume and scale of data processing. For example, filing of taxes, application for passports, driver license, trade permits, and professional licenses are now done exclusively online. Payment of goods and services is now being done. And data protection law is relatively new and evolving. And we recently passed the data protection, and the same was assented on 8th November 2019 and commenced on 25th of November 2019. The foundation of this act is the right to privacy as stipulated in Article 31C and D of the Constitution, which provides that every person has the right to privacy, which includes the right not to have information relating to their family or private affairs unnecessarily required or revealed, and the privacy of their communications infringed. This is not to say that before there was no some sort of protection of personal data. Before the enactment of this act, there are various laws that somehow protected personal or sharing of personal data. We can see there's laws such as Official Secrets Act, which classifies government information. There's the Children's Act, which anonymizes minors and patients and witnesses. Witness Protection Act. We have the HIV and AIDS Prevention and Control Act. Further, even financial information is still protected through confidentiality requirements under the Banking Act. We have Capital Market Acts. We have laws that require publication of data, such as Access to Information Act and Public Archives Documentation Service Act. We also have the Information and Communications Act, Private Regulation Act, which protects data collected during entry into buildings from being used for other purposes. We also have the ICT regulations under the Elections Act, which provide for protection of biometric data collected during elections. Other than that, we also have professional codes of ethics for certain professions such as doctors, lawyers, where information given to doctors and advocates is not shared to third parties. It's protected by client privilege and doctor-patient confidentiality. So these such codes of ethics prevents sharing of information to third parties. The Data Protection Act has borrowed a lot from the European Union General Data Protection Regulations, the GDPR. It has been said that we are compliant to these regulations. So I'll delve into the Act, and the object of the purpose of the Act is to regulate the processing of personal data, to ensure the processing of data of personal data of a data subject, to establish the legal and institutional mechanism to protect personal data, and to provide data subjects with rights and remedies to protect their personal data from processing. The Act has further established the Office of Data Protection Commission. It has provided for regulation of processing of personal data and rights of data subjects and obligation of data controllers and processors. while the establishment of the Office of Data Protection Commission is found in Part 3 of the Act, from Section 5 to 15. This part provides for parameters of appointment of data commissioner, qualification of data commissioner, functions of the Office of the Data Protection Commissioner, powers of the data commissioner, vacancy of the Office of the Data Commissioner, and the removal of data protection commissioner. Now, since the act was commenced, the office is not yet into operation, so it's making it hard for implementation of this act. So it has been about 7 months now, but probably it's. I know they've already been appointed and the names submitted. 3 names.
I don't think they've been appointed, but should be appointed.
PSC. Because
PSC has already cleared the names.
Yes.
The names to be forwarded, I think, to the National Assembly. They are supposed to be vetted by the National. Okay, the president is supposed to appoint the DC subject to
the names recommended.
Support
of the National Assembly. But that has not yet been done, so which begs the question why and when it will be done. So as it is, the act is still.
It's supposed to be
especially right now.
But with everything that is going on, it makes no sense that it has stalled.
Yes.
Because right now almost everything is being done digitally.
Yes. So
it's important
it
to
is.
really have this working.
Yeah. So Doreen will take us through the registration.
I'll be taking us through the principles that govern the Data Protection Act, the registration and who is required to register with the Act, and also the rights of a data subject. The principles of the Data Protection Act, which are in Section 25, are born out of a derivation from other legislation, both local and international. And the main principle that was cited was the right to privacy of the data subject. The data subject is basically the person from whom the data controller or the data processor is getting this information from. And the right to privacy is covered in the Constitution, as Phoebe had earlier mentioned. And the second principle is that personal data is processed lawfully, fairly, and in a transparent manner. Ideally, when someone is taking data from a data subject, it's not supposed to be hidden, or there need not be any agenda behind it. The data subject needs to be aware that they are giving this information willfully, and they know why they are giving this information to the data processor or controller. The personal data is collected for explicit, specified, and legitimate purpose, where, as earlier stated in the previous principle, the data subject has to be aware of the reasons why they're giving out this information, and it has to be with consent. Personal data is adequate, relevant, and limited to the purpose of its processing. So if, let's say, you are applying for a KRA PIN as a first timer, there are basic things you need to provide the data processor, who is KRA. So you cannot now start talking about what you like to do, what you do during the weekends. That is not necessary. You are only supposed to give information which is necessary for you to be given a KRA PIN. That is what this principle dwells on. Personal data relating to family or private affairs is only processed where a valid explanation is provided. So no one is supposed to ask you about your background unless it is necessary. For example, when they were doing the census, was it last year?
Yeah, last year.
You had to give all this information so that they know how big your family is, who are the members of the family, what kind of family you have. But otherwise, if you're applying maybe for a job, or maybe you're applying for even getting a line, basic things, it's not necessary for someone to do a background check on you.
Did they ask for background checks when they were doing the Huduma bill registration? Do you remember when they were doing the Huduma bill?
Background checks in that they were just asking
Hadi where your shags is.
where you live. But they were not necessarily asking. Did they ask us about our parents?
Yes, they did ask about our parents. I think they even asked. Did they ask about grandparents? Man, they asked.
But I think the Huduma number was almost relatable to getting an ID. Because when you were if you did the traditional filling the form, going to the chief, the DO, signing, you had to fill your father's details, your mother's details, where you come from, even if you were not even born there. I think they were taking the path of the registration of an identification card. So maybe it was somehow important. Also, the personal data is accurate and up to date. You are supposed to give information as at the time. You cannot give information that is false, or people can, but when you are gotten to have canvassed information, when it makes maybe for the government very difficult to work with, and also false information might lead to a lot of things, and it is also a crime to canvass. Personal data is kept in a form that identifies the data subject for no longer than necessary for the purpose. There are things that last for I don't want to say forever, but for as long as they are useful. Like I will use the KRA pin because it seems feasible. The KRA pin, it collects data on who is employed, how you pay your taxes, who has a business, who is a student. So for as long as this exists, and you see it keeps updating itself from you moving from becoming a student to you becoming employed or having a business until you stop employment. It always keeps this going. But if you perhaps say just applying for a job for a certain period of time, those people are supposed to have only the information that they have of you at that time. They cannot keep this information for. And besides, when you're applying for a job online, you get the option for deleting an account. I think that is what this principle means. Personal data is not transferred outside Kenya without consent of the data subject, or if there is consent, there must be adequate data protection safeguards. So I will peg this on maybe mergers and takeovers. You see, like maybe companies who come into the country and buy other companies out, or maybe a local company buying another foreign company or taking over. These people need to be the people who the company is buying data from. They need to be informed. They need to be aware that their data is being transferred based on certain agreements. And these people need to be aware of the laws that govern those countries. So if you consent to maybe your data being taken over by a company where data protection is not embraced, it poses a risk. And that's why these things need to be taken account to. So those are the principles as in the Data Protection Act. So we'll go straight into the registration. The registration in the Data Protection Act is quite wide because it also gives the obligations of the data controller, the data and the data processor. But I will only give you the basics where who is required to register with the Data Protection Commissioner and what is the threshold that is required in the registration. So any person who acts as a data processor or a data controller is required to register with the Data Protection Commissioner. So the thresholds that will be considered in determining the requirement for registration of a data processor or a data controller include the nature of the industry, the volumes of data processed, and whether sensitive personal data is being processed. Agnes will be taking us through personal data and what is sensitive personal data, so she will expound on that, and any other criteria that the data commissioner may specify. Failure to register as a data controller or a data processor is an offense according to the Act, and the penalty is 3 million Kenya shillings or imprisonment of 10 years or both for such an offense. The next thing I'd be talking about is who is a data subject and what are the rights of a data subject, as in section 26. A data subject is an identified or identifiable natural person who is the subject of personal data. That means that it is a person who can be identified directly or indirectly by reference to an identifier such as a name, an identification number, location data, an online identifier, or to one or more factors specific to the physical, psychological, genetic, mental, economic, cultural, or social identity. So the rights of a data subject include the right to be informed of the use of their personal data, the right to access their personal data in custody of a data controller or a data processor, the right to object to the processing of all or part of their personal data. I remember in last year's census, there was a lot of talk about some of the questions that were being asked, like how many, if you have a phone, what kind of phone it is, and how many of them are in your house. Mm-hmm. Also information like your phone number and your status of employment. Yes, these things are meant to give the government an overview of how or what kind of lives people in different parts of the country live. But I believe such information, if it gets leaked or if someone misuses it, it poses a risk to the person who has given this information. And many people were considering such personal questions to be risks to their own privacy. That was to access the personal data. They also have a right to correction of false or misleading data about them, and the right to deletion of false or misleading data about them. So I think safe to say those were very direct. And now Agnes will take us through the grounds for processing of sensitive personal data.
Thank you, Doreen. Before I get to my segment, I think I should give definitions to a few phrases that we're going to use under that particular segment. First of all, health data means data related to the state of physical or mental health of the data subject and includes records regarding the past, present, or future state of the health, data collected in the course of registration for or provision of health services, or data which associates the data subject to the provision of specific health services. Personal data is defined as any information relating to an unidentified or unidentifiable natural person, whilst sensitive personal data means data revealing the natural person's race, health status, ethnic social origin, conscience, belief, genetic data, biometric data, property details, marital status, family details, including names of the person's children, parents, spouse or spouses, sex, or the sexual orientation of the data subject. The grounds for processing of sensitive personal data are covered from section 44. This particular section states that sensitive personal data shall not be processed unless they are applied as per section 25, under which section 25 talks of the principles of data protection. That means any sensitive personal data cannot be processed unless it's subject and lives up to the principles of data protection principles. But there are also permitted grounds for processing of sensitive personal data. This would be the processing is carried out in the course of legitimate activities with appropriate safeguards by a foundation, association, or any other not-for-profit body with a political, philosophical, religious, or trade union aim, and on condition that the processing relates to solely the members of the body or to persons who have regular contact with it in connection with its purpose, and the personal data is not disclosed outside the body without the consent of the data subject. So at all times, these particular institutions that are mentioned here would be political parties, religious institutions, churches, mosques, temples, what have you, trade unions, etc. They cannot record or process any sensitive personal data unless the data subject knows and consents to it, and the same data cannot be disclosed unless the data subject consents to it. Further, this particular section talks of the processing of personal data which is made manifestly public by a data subject. That means if an individual, for instance, decides to go public, maybe on social media, newspapers and whatnot, and discloses personal information, maybe their health status, their sexual orientation, their political affiliation, their religious affiliation, then that's on them. That is entirely on them. That is consent by a data subject. And I would like to mention at this point that at any particular point, that information relayed or published or disclosed can be used against you, either by the government, either in a court of law, either by members of the public, and you cannot seek reprieve for data that you have personally consented to disclose. Yeah. Also, there are permitted grounds for processing of sensitive data where, as per the Act, it is necessary for establishment, exercise, or defense of a legal claim. In instances where purpose of carrying out the obligations and exercising specific rights of the controller or of the data subject, and also where one is protecting the vital interest of the data subject or any other person where the data subject is physically or legally incapable of giving consent. The next part talks of personal data relating to health, and this part provides that personal data relating to the health of a data subject may only be processed by or under the responsibility of a healthcare giver. This will be doctors, hospitals, clinical officers, nurses, and whatnot, or even paramedics, first responders. It would also be by a person subject to the obligation of professional secrecy under any law. Again, this brings in the doctrine of confidentiality. Would be doctors and anyone who is involved in securing of data as regards personal health of an individual or a data subject. Now, further to this, there are conditions that must be met for the said data to be processed. First of all, the data must be necessary for reasons of public interest in the area of public health. I think the best example would probably be a database for HIV infections. They don't necessarily have to give your details or markers that are identifiable to you as a data subject, but the government must be able to create a database so that they know the rate of infections, how to provide ARVs to patients. And for instance, again, like right now, we're in the middle of a pandemic. The government has to create a database on a daily basis that is revised and updated on a daily basis as regards infection rates, deaths, and recoveries. And B is carried out by another person who in the circumstances owes a duty of confidentiality under the law. Now, this particular segment goes to further categorize sensitive personal data, and in this particular section, it gives the role of the data commissioner in as far as personal sensitive data goes. The data commissioner may prescribe further categories of personal data which may be classified as sensitive personal data. And then where categories of personal data have been specified as sensitive personal data, the data commissioner may specify any further grounds on which such specified categories may be processed. And this is having regard to any particular risk of significant harm that may be caused to a data subject, where the expectation of confidentiality is attached to such category of personal data, as to whether a significantly discernible class of data subjects may suffer significant harm from the processing of such data, and to the adequacy of protection afforded by ordinary provisions applicable to personal data. It also proceeds to state that the Data Commissioner may specify other categories of personal data which may require additional safeguards or restrictions. To this end, I think the best example I would use is mobile banking transactions. When you go to supermarkets, when you go to, your ordinary shoe shops where you have to buy and they do marketing on, the mobile phone platforms. After some time, you start getting texts, ads, stories about discounts for mobile transactions, where you start getting messages from these particular supermarkets, the shops and whatnot. I think that is a breach of personal data. That was not the intention of why you would give your number, or your number would somehow end up with the vendor. There's also this thing where sometimes after performing a mobile banking transaction, when you're about to walk out of a said establishment, somebody asks you to write down the M-Pesa transaction and the number that you've used and all that. You have every right to refuse. They have no one has any right to ask you for your contacts, for your details, for this and that. When you walk into a shop, you only do your transaction and you get out.
The worst part is usually when they send you those promotional messages. And then they still send an alternative to, if you don't want to receive more, send stop to, or go to star, what. In the first place, you didn't sign up for it.
Exactly.
So it makes it tasking to keep on unsubscribing from something you did not even subscribe in the first place to.
Which I think would also should be a challenge to mobile network subscribers. Why in the first place are they allowing some of these things to happen? Because when you think about it, sometimes it's not even the fact that you performed a mobile transaction. You just get random messages.
Pigabet or
yes,
things,
gambling things. Mara, you're getting messages, encouragements, prayers, ringback-tone things, funny things, and you did not subscribe to anything. So you wonder, how are these particular people getting your numbers? And then it's not your orthodox, your standard mobile number. So further to the mobile transactions and breach of privacy by business entities, I would like to raise the issue of the DCI in taking of mugshots. Is it mandatory? Is there any legal provisions that says when you're a suspect, when the DCI comes and arrests you, they can actually arraign you somewhere, take your photo, and have you hold a placard with your name, full name, ID number, phone number, and your charge, whatever they're charging you with? Because I think it's a huge breach of personal data or right to privacy, and it also goes to contest the
right of presumption of innocence.
Exactly, the right of presumption of innocence until proven guilty. So that is something I think should probably be addressed by the Data Commissioner. And they normally do this on Twitter. They will take your photos, and especially when it's a controversial issue, offense, crime, they take your photo, they post it on Twitter while you're holding a placard, and it looks like a mugshot. And I'm thinking, since when, and who gave them the right to do this? Yeah, it's different when it's a courtroom. Yeah. Something else maybe the Data Commissioner should consider is social media and how social media companies use a data subject's data. There's a particular social media platform, like you can even go and read through its privacy policy, and they talk about how they actually use, they will actually try and find out your device, what kind of device you're using, the IP address, and they'll even go as far as finding out your location, your call logs, your messages, your contacts, so they can create an algorithm of people who might be familiar to you and use that to have you connect with these particular people. That is also something the data commissioner should look into, because that is an extremely huge breach. When you think about it, almost all the social media companies that are operational in Kenya are not Kenyan. They are foreign entities, some of whom have been accused of using personal data and selling this particular data to ad companies, so that ad companies using certain algorithms can target you for their ads and so on and so forth.
I think people need to be aware of the terms and conditions part of these apps, because you when you sign up just for Google, to access an Android phone, Google is the best.
Yes.
The best to make you work around your phone, and the default settings usually is that you accept for them to use your data,
Your
access
personal
location.
information.
And many people don't know this. You just skip to the I accept and go.
Moving
But
on.
there's a part where I think in the settings where you can change these settings. If you don't wish for them to identify your location, if you don't wish for them to identify your contacts, or you don't wish for them
You don't even wish for cookies to trace your information, trace back to you.
When you change these settings, some of these things will die down, not completely, but you will see a difference. I think people are not aware that these things are there. Maybe if you take time to read the terms and conditions, it will be nice, because anyway, ignorance is not
a defense.
Yeah. So we can't fully blame them, but as the public, we need to create awareness on this.
Yes.
To add on that, however, when you download any apps from Play Store or Apple Store, most applications, there's a requirement for you to operate that application. It must access your contacts, your information, your photos, and everything on the phone. So it becomes very limiting, because I want to benefit from Google, I want to benefit from maybe Uber or any app, or Twitter, but then it must access my personal information.
And they always convince you that for it to work better, you need
exactly.
to access it.
If you don't accept, you don't do anything. You cannot do anything on that app. So it's also very.
But see, for them, it's like you have consented.
You've consented.
You want to use it,
exactly.
consent.
And that is where I think the data commissioner comes in creating safeguards and extending the categories of personal data that needs safeguarding and restriction for software companies and so on and so forth. Yeah, so that is it from me. Until our next episode.
Yeah, thank you so much for listening to our podcast. Join us next week on the second episode, where we will further discuss the transfer of personal data outside Kenya, the exemptions of processing personal data by a data controller or data processor, as well as the impact of the Act in the use of digital technologies in data processing. Thank you, and the content of this episode is intended for general use and cannot be relied upon as legal advice. Goodbye, and see you next week.
Bye-bye.
Goodbye.